Ernest Hilaire against Appellant Chastanet.
Yes, Mr. Estefan.
Good morning, my Lord. Thank you very much. My Lord, in our submissions to the court, we intend to deal relatively briefly with three issues: the proper interpretation of Article 917A, the constitutional question, and if necessary, the question of the inconsistency between the legislation, 2013 legislation, and the Article 989 of the Code.
Yes.
My Lord and my Lady, our first submission is that the Court of Appeal, in its interpretation of Article 917A, focused, as does the respondent, almost exclusively on the words, the laws of England. Your Lordships and my Lady will see that, particularly at paragraph 25 of the judgment of the Court of Appeal, which is at page 131 of the electronic hearing bundle, and at paragraph 44, which is at page 23. And the findings of the Court of Appeal on the meaning of the laws of England are repeated by the respondent at paragraphs 47 to 51 of their submissions, which is at page 699 of the electronic bundle. Also at paragraph 52, which is at page 770. We respectfully submit that the Court of Appeal fell gravely into error in so construing the Article 917. And if I may ask the court to kindly look at Article 917, which is at page 927 of the electronic bundle.
Sorry, page 9.
I'm sorry, my Lord, 927.
Thank you.
At the very top of the page, your Lordships will see subsection 3, which is subsection 3 of Article 916A. And I would ask your Lordships and my Lady to have a look at the language used in 916, paragraph 3, which is subject to the provisions of this code or any other statute, the law of England for the time being in force governing the rights, powers, and duties of trustees and beneficiaries under trust shall extend to and apply in the colony. Paragraph 917A, Article 917A, subparagraph 1 is at the bottom of the page. It says, subject to the provisions of this article, from and after the coming into operation of this article, the law of England for the time being relating to contracts, quasi-contracts, and thoughts shall mutatis mutandis extend to this colony. Note the words "and shall apply" as seen in Article 916 are not to be found in that paragraph. It goes on, and the provisions of Articles 918 to 989, we are concerned about 989, which sets off in the code the provisions.
Why do you say that? Because 989 is to do with something different. The libel provisions are 989F2S. So it doesn't seem to me that these are included in that part of subsection 1.
Well, my Lady, we have interpreted 989 to include all of the subparagraphs of the article.
They're not subparagraphs of 989. They deal with all sorts of things. 989A deals with dogs biting cattle, and
no, well, my Lady, may I take you to 989F?
Yes, but at the moment, I don't accept that 989F onwards are included in this, the part of 917A, the second clause of it. That wording was introduced in 1956, which is by the same act as the Articles 989A onwards, but it wasn't thought necessary to include those in this additional wording in 917A.
Well,
989 is something to do completely different. It's nothing to do with libel law.
Well,
Is there some rule that you can point us to that says that if articles have a letter attached to them, they're treated as somehow part of the article without the letter?
well,
Not how
my lady,
statutes are
we
drafted.
don't have any reference to that because that was never an issue in the matters coming up. But if we look solely at Article 989, which is at page 943 of the electronic bundle, all that 989 says is an action in respect of delict or quasi-delict does not prejudice and is not prejudiced by criminal proceedings in respect of the same subject matter. We have in the High Court and the Court of Appeal proceeded on the basis that 989 included from paragraphs 989F right through to page 954, which is the last page dealing with libel and slander.
Where do you show us, where is that? Where do you say that is?
Page 948.
Where in the Court of Appeal's judgment do they do that?
I can get it for you, my lord, my lady, 1 second. Part of the issue before the High Court, as well as the Court of Appeal, was whether or not the Defamation Act of England of 2013 applied in St. Lucia and because of the provisions of Section 917A. That was the case before the High Court.
Yes, no, I fully accept that. I fully accept that the first part of 917A1, and I also accept that 917A3 is relevant here. The only bit I'm querying is the reference to those specific articles.
Well, my lady, if we have a look at paragraph 40, where the court at paragraph 40, I think it's page 21 of the bundle.
Sorry, I didn't catch the page.
I think it's, I'm checking it for you right now, my lord.
No. He hasn't got a lot of time to get.
Oh, okay, I just...
It's at page... I'm sorry, my lord, just bear with me a minute.
Well, perhaps we can come to it later, Mr.
Estefan, I think probably because of the limited time, it would be better if you continue with your submissions, making the best use of the time available. We can return to this later if necessary.
Yes. Well, my lords and my lady, I can continue simply on the basis as follows. The entire litigation between the appellant and the respondent turned on whether the Defamation Act 2013 applied in the jurisdiction of St. Lucia. The argument before the High Court and the Court of Appeal was that insofar as the specific articles named in Article 917, that the Article 917 required it to be construed in accordance with the laws of England, as opposed to be replaced, repealed, or made redundant simply because there was a conflict or no conflict between Article 989, which dealt with the defamation, libel, and slander, and the Article 989 and Defamation Act 2013. The High Court judge agreed that the statute could not apply. The Court of Appeal disagreed and applied and said that the 2013 Act applied, and as a result of which held that a number of the provisions of Article 989, which concerned libel and slander, had been made redundant because it had repealed the common law defenses of justification and fair comment.
Yes.
And as a result of which the provisions in the code that dealt with defamation had become redundant. And we had argued, and we are arguing before this honorable court, that that was not the intention of the provisions of the Act. If we can ask the court to look at the article of Sir Vincent Flossack, it starts off at page 1732 of the electronic bundle, but the page that I would like to refer to is at page 1737, where he refers to the mandate given to the drafter of the Ordinance 34 of 1956 and to the purposes of it. And he said, on the fourth paragraph of that page, he said, Sir Allen was empowered by under section 4.3 of the 1954 Ordinance to assimilate the code to the law of England where they differ in the light of the present needs of the colony and to prepare draft measures suitable for the enactment by the Legislative Council. The products of Sir Allen's opus magnus included the Civil Code Amendment Ordinance, which came into force on the 30th of June 1957. The 1956 Ordinance imported English law into our Civil Code to an extent unsurpassed by such importations under previous amendments. And then at paragraph 1738, he says, he sets out in other cases the importation of English law has been expressed. And he dealt with 91.7a, etc. And then in this third paragraph, as a result, these and other new articles which were introduced by the 1956 Ordinance, many important branches of our law were assimilated to English law. Now, my lady, when we look at the Civil Code, 989, my lady would see at page 9, I'm sorry, I'm trying to
989 is the Constitution, Mr. Astafan.
No, I know. I was referring to this section of the
Article 989.
of the code. I wanted to refer the court back to the code, if I may. I'm trying to find my particular page. As I pointed out, my lord, that's at page 9.
You mean 943? Page 943, is that it? Article 989?
Yes, my lord. At the very last page of 989, which is at page 954.
All right. 954.
Your lordship and my lady will see that this article 989 was in fact added by the very same Act 34 of 1956. It wasn't just Article 989 by itself, but all of these sub-rules concerning defamation were brought into law by the very same Act. And based on that, we are saying that the reference to 917A to 90 to Article 989 would have included all of the articles that were brought into force in the Civil Code by Act 34 of 1956. and that it is not limited simply to Article 989, as your leadership seemed to have indicated. It was the entire parameter of the articles that were brought into force, and therefore...
I'm sorry, I didn't hear it. It was, what do you say is brought in?
All of the articles relating to Article 989, not just Article 989 itself. And that when we respectfully submit, when the drafters, Sir Alan Lewis, referred to 989, in Article 917A, he was referring to all of the articles that have been brought into force by the very same Act. Because this is what Sir Vincent Flossack said. The purposes of this amendment was to bring the laws of St. Lucia closer to the law of England. And this included the law of libel under Articles 989F all the way over to page 928. There was a comprehensive code for libel and slander introduced into the laws of St. Lucia by the amendment made. And therefore, our argument at the High Court and the Court of Appeal, and now before this Honorable Court, is that in view of the language used in Article 917A, that Article 989 and all of its sub-articles or sub-paragraphs are from the enactment of this amendment were to be construed, not to be replaced, to be construed by English law.
Can I just ask you, Mr. Astafan, before the reform in 1956, was there any law on libel and slander contained in the civil law of St. Lucia?
It was the common law. I think this was the first introduction to the law of libel and slander. And the other point that I would make, which is what Sir Vincent Flossack makes in his article, is that prior to the introduction of Act 34 of 1956, which introduced the law of libel, which my learned friend argues on the other side, came from the 1952 Act of the United Kingdom. The civil code, or most of the civil code, was because of the occupation or conquest by the French, interpreted in accordance with French law, either the law of Lower Canada or the Costume de Paris. And the whole purpose of the amendment was to introduce, as a colony of England, the laws of England, and in the specific circumstances of libel and slander, to actually codify the law as part of the laws of St. Lucia. And this is why we respectfully submit the language of 916A subparagraph 3 and 917A are different. 917A was intended to allow to stop the interpretation or construction of these provisions in accordance with French law, and to have them construed, all of them that were brought into force by the Act in 1956. To be
so can I just be clear, Mr. Astafan? This is not, when it's described as a civil code, it was never intended, was it, to be a comprehensive code. You're saying that prior to the reform in 1956, there was no law of libel and slander other than under the common law. You're saying there was nothing in the civil code that applied to libel and slander. Is that correct?
Well, my lord, I can get instruction from my colleagues in St. Lucia, but my understanding was that the libel and slander provisions under Article 989 were introduced by the amendments made in 1956.
It strikes me, it's a very odd code or civil code if it's not intended to be comprehensive. That's what I'm struggling to understand.
It is a comprehensive code, my lord, because in the very same article of, first of all, in the High Court judgment of the learned judge, he dealt with the question of whether it was a comprehensive code or not. And what he did from about paragraph 40 of his judgment, let me get you the page as quickly as I can.
Well, we have it at page 127 of the hard bundle.
It's and the electronic bundle which I have is at page 58 of the electronic bundle, my lord, my lady, where he set out the provisions of the code from paragraph 37. Came to the conclusion at paragraph 40 that the code expressly provides for the defenses of fair comment and justification. And at paragraph 41 to 43, at page 59 to 60 of his judgment, he considered the language of Sir Vincent Flossack in his article, the same one I just pointed out, the interpretation of the Civil Code of St. Lucia, and he says, Sir Vincent Flossack says that the code needs to be construed in accordance with the Vagliano principles in a way that it is an exclusive, comprehensive code, and that in the absence of some extraordinary circumstance, like some examples he gave, the language is not clear, the language is uncertain, that it is to be considered as a comprehensive code without the introduction of external factors such as what the existing law was before and what changes may have been made. So I ask you...
But how can that be the case with, for example, 989K dealing with justification, to take one example? That can't be a self-contained provision because it doesn't tell you what a defence of justification is. It just tells you that it shall not fail in a particular circumstance. Do you say that there's anything in the code which tells you when a defence of justification arises, generally?
Well, my lord, that may be one of the exceptions pointed out by Sir Vincent Flossack for looking outside of the code. If the word justification, there's no statutory definition of justification, then you would be entitled to look at what the pre-existing law was, according to him, to determine what does fair comment and justification mean. In the article that I referred your lordships and my lady to, he draws the exceptions to the Vagliano principles. At page, he dealt with the Vagliano rule at page 1741 of the code, of his article, and then he goes on to give...
But do you accept that what you then have to do to find out what justification means is to look to the common law of England?
Yes, I think that could fall under one of the exceptions to the Vagliano rule at page 1745.
Yes.
I accept that, because if it doesn't give its meanings, if there's no way of ascertaining the meaning within the code, then that would be considered by Sir Vincent Flossack an exceptional circumstance which would permit us to look at what the common law was.
Yeah. Well, then the argument against you is that when the common law of England is abolished by statute, as it was in the recent Defamation Act, what you then have to look at is the statutory law of England, which is then now contained in the in the latest Defamation Act. And even if 989K stays, it's got nothing to bite on because the common law defence of justification has been abolished. So what is your answer to that argument which is put against you?
Well, the argument would be that, well, I think the English common law of justification and fair comment still applies in the OECS states, notwithstanding it being abolished in the United Kingdom. My answer to that would be that the law, by expressly providing for justification and fair comment in the way that it did, and privilege and the presumption of damage and other stuff in the code, that would have been an exception that may have applied, for example, with Article 917, subparagraph 3. If it's inconsistent with the provisions of the code, then the code will prevail. An act that seeks to abolish the law of justification and fair comment would clearly be inconsistent with the code that has expressly entrenched the defense of fair comment and justification, even though its meaning may be in the common law, and that it will remain unaffected by the Act because of 9173. And this is why in the Court of Appeal and in this court, my learned friend is arguing, well, if the law of justification and fair comment is abolished, then that means the acts become, the provisions of the code become redundant, and therefore the Act of the United Kingdom would apply in full force. And I respectfully submit that would not have been the intention of Article 917A at all. My lords and my lady, all of the authors...
Mr. Van, could I bring you back to 917A, which is at page 927? And you refer to the phrase, and the provisions of Articles 918 to 989 shall, so far as practicable, be construed accordingly. I view that as an interpretive obligation. It doesn't, the first step is to see whether there are laws of England from time to time related to contracts which extend to St. Lucia. And thereafter, if they do, there's an obligation, insofar as is practicable, to interpret those the code in accordance with the laws of England. And so I'd be interested in your answer to that. And also, I would be grateful for information as to whether Articles 918 to 989 and 991 to 1132 all relate to contracts, quasi-contracts, and torts.
My Lord Stevens, I thank you very much for that. Yeah. Your first question is answered by the position we had in the High Court and the Court of Appeal, and now before your Lordships and my lady, that the provision required the interpretation of Article 989 and not its replacement by English law. In fact, if you turn the page over, the 926, 928, it said, and the said article shall cease to be construed in accordance with the law of Lower Canada or the Costume de Paris. So your Lordship is quite right. 917A, as we've been arguing for the last few years, is an interpretative provision and not one that seeks to alter, amend, or make redundant the provisions of the article.
I was on a slightly different point, and that was, the first step is you see whether the laws of England extend, and then you have an interpretive obligation to make the code comply with those laws so far as practicable. And 917A3 then says, well, if it's not practicable, the code prevails.
Well, our position was and remains that insofar as the Defamation Act of England, as my learned friend submits, seeks to amend and alter, make the code redundant, it is clearly an inconsistency that was intended to be dealt with under Article Paragraph 3. Because it is inconceivable that a provision that requires an interpretation in accordance with English law could, rather than interpret it, deal with it in such a manner that it becomes redundant and replaced by provisions of a United Kingdom Act made after after independence of 1978 and passed into law in 2013. All of the authors that dealt with the code speak of the difficulty in interpreting the the provisions of the code. But it, simply put, before I move to the next issue on the question of the constitutional issue, what we want to submit finally on this point, my lords and my lady, is that Article 917A, insofar as Article 9 was concerned, which includes all of the sub-paragraphs or sub-articles, was intended to ensure that these provisions were construed in accordance with English law and no longer in accordance with the law of Lower Canada, Costume de Paris, because following the establishment of the colony of St. Lucia by England, the Legislative Council wanted to ensure that English law governed the construction of these articles and not the law of France. And we respectfully submit it is inconceivable that the clause that that requires interpretation could, as the Court of Appeal held on the persuasive arguments of my friend, lead to making provisions of a code redundant, which is in effect constitutes an express or implied repeal. That is surely not the function of Article 917A. May I, my lords and my lady, go to the constitutional question?
So can I just be clear that I understand the main submission you've made, Mr. Astafan? Is it that you have got in St. Lucia, under the provisions of 989 onwards, or perhaps not 989, but
F onwards.
F onwards, a fully coherent law on libel and slander, and that in order to accommodate English law, one could not do so by a consistent interpretation. You would have to put a line through all those provisions. They can't, in other words, be assimilated with the reform of the 2013 Act. Is that the submission?
Yes, my lord. Yes, my lord. Because it says the laws of England shall apply mutatis mutandis, and so far as practicable be construed. I mean, these words mean something.
And you say you just can't do it if you include the 2013 Act. It becomes incoherent.
It becomes incoherent. It becomes like a hybrid provision, part code, part English law. And but our main objection, our main submission, is that the requirement to construe as far as practicable a provision in accordance with English law ought not to lead to the conclusion that the code needs to be, as the Court of Appeal and my learned friend argue, made redundant, which we submit is a form of repeal and replacement by the English Act, which was never the intention of Article 917A. I mean, surely if the code codifies the defense of justification and the English Act abolishes it, that clearly creates a major conflict. Can I go in the interest of my time, can I move to the next subject, my lords and my ladies?
Yes, please. Thank you, Mr. Estefan.
My pleasure, my lord. My lord, our case on the constitutional question is very simple. Is it the law of St. Lucia that a provision such as article, on the assumption it imports a statute, the Act of 2013, whether Article 917A, which was enacted during colonial times, even before associated statehood, with all of its constitutional implications, and now the 1978 Constitution, that such a provision could survive the constitutional test of creating what is clearly a parallel lawmaking authority importing statutes from the United Kingdom and bypassing the constitutional requirement of the laws of St. Lucia being made by the Parliament of St. Lucia, and whether having to construe Article 917A in accordance with Section 120 of the Constitution, whether the inconsistency is such that it must be to that extent be declared void. It is, as a matter of constitutional theory, difficult to accept that a law made in 1956 could continue to determine what the statute laws of the independent state of St. Lucia. My Lord, if I may ask you to have a look at paragraphs 40 and 47 of the Constitution, that's at page 989 to 992. Paragraph 40 is at page 989.
Yes.
Subject to the provisions of this Constitution, Parliament may make laws for the peace, order, and good government of St. Lucia. Paragraph 47 is at page 992, which deals with the mode of exercise of the legislative powers. There are 4 subparagraphs. We ask your lordships to have a look particularly at subparagraph 4. No law made by Parliament shall come into operation until it has been published in the official gazette, etc. So there's a constitutional procedure for the determination of the laws of St. Lucia. One,
but are these laws made by Parliament, Mr. Estefan? Are we concerned with laws made by Parliament?
No, we are not. We are concerned with a colonial law which conflicts on its face with the provisions of the Constitution that vest the power to make laws in
the Parliament. So why does 47.4 apply?
47.4? No, it applies because it shows what the constitutional lawmaking authority is required to do. If I can ask you to have a look at paragraph 120 of the Constitution, which is at page 993. It says, this Constitution is the supreme law of St. Lucia and subject to the provisions of subsection 41. If any law is inconsistent with this Constitution shall prevail.
Sorry, yes, 120.
Yes, my Lord.
Yes, thank you.
Page 993. Our argument on the constitutional question is straightforward. That a colonial law which imports or permits the importation of statutes made by the United Kingdom which remains applicable after the enactment of the Constitution and the vesting of what we say is the exclusive lawmaking authority in the Parliament on a council, on an act or a provision that was made during colonial time is inherently repugnant to the provisions of the Constitution. You can't, unless the sovereign Parliament of St. Lucia, in the exercise of its discretion, seeks to specifically import a particular law of the United Kingdom, or Australia, or Canada, or any part of the Commonwealth. That is one thing. But it would be for the sovereign Parliament to make decisions as to what should be the laws for the peace, order, and good government of the people of St. Lucia, and not a law made in 1956, which was intended to assimilate English law to St. Lucia in colonial times.
So do you say that 917A is invalid and has no effect now? Indeed, has never had any effect under the Constitution?
Well, we are saying certainly after the 1967 Associated States Constitution, and definitely now after independence with a sovereign parliament, that any other lawmaking authority that's inherited from colonial times ought to be declared unconstitutional and null and void.
So it's back to the civil code without any English law construction, is it?
Well, I think our point is that it would be for the Parliament to determine post-independence whether the English law of defamation should apply. As happened in the one or two of the Privy Council cases that my learned friends relied on. It was the Sovereign Parliament of St. Lucia that made sections of the PACE applicable to St. Vincent and the Grenadines. So the Sovereign Parliament can do it, but it ought not to be a colonial law which permits contracts, quasi-contracts, and torts to be imported. In constitutional times, some of us would say through the back door ought not to stand. My learned friend relies in answer to the second schedule to the Constitution, which is at page 1713. If I can just get it, 1713.
1713.
Yeah, that's an actual 1713. He's relying on section 2 of the second schedule.
Yes.
Which is the existing law shall from the commencement of the Constitution be construed with such modifications, adaptations, qualifications, exceptions as may be necessary to bring them into conformity with the Constitution and the supreme law. We accept that. But if your lordships and my lady looks higher up, you see the word transitional provisions. And we respectfully submit two things. That the Governor General or the Parliament could, in accordance with subsection 2, do certain things to bring the laws in conformity with the Constitution, but they did not. And we stay one step further that the paramount provisions for consideration by this court is not the transitional provisions of savings existing laws in accordance with modification. It's actually section 120 of the Constitution, which says, if any other law is inconsistent with this Constitution, this Constitution shall prevail, and no other law shall to the extent of the, and the other law shall to the extent of the inconsistency be void. And the constitutional effect of section 120 is that it reaffirms the fact that the Constitution is the supreme law of the land. And therefore, there ought not to be any parallel or alternative source of lawmaking authority that bypasses the regime provided for under the Constitution.
So Mr. Hilaire, your client, has brought these libel proceedings in the St. Lucia court. What law, then, does he look to for giving him a right to bring that claim in libel in St. Lucia? What is the law on which he relies to give him a right of damages?
I think we have it in here. I don't recall offhand, my lady, my learned friends in St. Lucia can probably point me to.
Is not the answer going to be the common law of England as imported into St. Lucia?
I don't recall right now, my lord.
What?
I don't recall whether it was the common law of England. I'm trying to find the statement of claim right now. It's at
well, surely you know what your client's cause of action is based on.
Yes, indeed, my lord. As I said, I just don't. I have it now.
The claim form is at 151.
I have it now, my lady. It would be the common law. And it would be prosecuted and dealt with in accordance with the provisions of the code.
Well, according to you, that's all been wiped out by the Constitution. Because English judges can't override the power of the St. Lucia Parliament. So if your argument were correct, it would obliterate your client's claim.
Well, my lords, we do not accept that our point on the constitutional question is that following the Constitution of 1978, the importation of laws from colonial times ought not to be allowed to continue and would be unconstitutional.
Well, I understand that, but if we look at paragraph 2, subparagraph 2 of Schedule 2, which is on page 1713, you just took us to it, that makes provision for existing laws at independence to continue to have effect. Now, do you say that Article 917A was void from was void from the date of the Constitution, or do you say that it was void before the Constitution?
From the Constitution. In fact, my lords, the subparagraph 2 makes provision for things to be done, but your lordships, in the case of Brown versus the Queen, which is to be found at page, well, the part of the judgment that I would like to refer to is at page 1855. At the very bottom of the page is a judgment of your lordships in Brown versus the Queen.
Yes.
Where your lordships pointed out that the equivalent provisions in Senkage, that the Governor General nor the Parliament made any changes to the existing law. And at the bottom line, your lordships found, therefore, it is the duty of the court to decide what modifications require to be made to the offending provision in the proviso and to give effect to it in a modified form, not to strike it down altogether. That would clearly have been the position under the transitional provisions. But what we are saying, my lord, is that the paramount provision is in fact section 120 of the Constitution, and not the transitional provisions. And if the transitional provisions do apply, which we are not sure that it could in the face of section 120, it would in effect mean that the consequence of any inconsistency, whether the importation of the act is inconsistent with the powers of Parliament, the inevitable result, if section 120 applies, is that it will be null and void.
Thank you.
Mr. Astafan, again, doesn't Section 120 only apply to strike down a law if you've gone through the interpretive process in at page 1713 to try and make the existing laws conform with the Constitution? It's only if you fail in that endeavor that you then strike down the law under Section 120.
I think that's a permissible interpretation. I would think, because the second schedule and section 120 speaks to modifications and so on to bring it into conformity with the Constitution. But on the face of it, there first has to be a determination of inconsistency. May I just rephrase what I just said, my lord? Section 120 refers to any law being inconsistent. Section 120 provides the remedy for any inconsistency, which is that it shall be void. I am not sure, we are not sure whether the Schedule 2 provision, the Section 2 of the second schedule provision, as part of a transitional provision, may still be valid.
So just to be clear, what is the inconsistency that you say exists between the Constitution and the Article 917A of the Civil Code?
Yes, that it would be a matter for the Parliament of St. Lucia post-independence to make laws for the peace, order, and good government of St. Lucia.
And why isn't one of those laws, well, it clearly pre-existing laws carried on, didn't they? It wasn't starting with a clean slate in no laws at all.
No, my lord. The existing laws would have continued unless modified by the Governor General or until or by the Parliament.
So why isn't one of those existing laws 917A that carried on?
Well, it would carry on in its form until construed by the court in litigation, as in this case. And we have asked the High Court judge and the Court of Appeal, and now your lordships, to make that determination.
But why doesn't it just carry on? What stops it from carrying on?
Well, it would have carried on until the Independence Constitution. And I think our point is that following the Independence Constitution, a clause such as 917A would, if it continues to allow the importation of statutes post-independence from England, it is a law which would be inconsistent with the exclusive authority of the Parliament to make laws, including passing laws to incorporate or import acts from the British Parliament after 1978. And that a colonial law ought not to be allowed to continue post-independence laws made in colonial times to fit the, as Sir Vincent Flossack put it, to fit the circumstances of the colony at the time.
You wouldn't have a problem if 917A had been made by Parliament, or would you?
We would have no problem at all with the Sovereign Parliament of St. Lucia saying that a specific act of the British Parliament applies to St. Lucia. And that would be gazetted, and that would be published, and that would form part in accordance with Section 47(4), and that would become the law of the land of St. Lucia.
What about if Parliament enacted the exact same terms as Article 917A now? There'd be nothing wrong with that, would there?
Well, we would have a problem insofar as the accessibility to laws are concerned. We take the view that laws must be accessible and known to the people of St. Lucia. And a law which gives of general application and non-specific, just the laws of England in relation to contracts or torts or quasi-contracts.
But isn't that rather the tail wagging the dog? I mean, shouldn't they be, you may complain that they are not gazetting the Defamation Act 2013. That may be a justified cause for complaint, but presumably it's up to the government or Parliament to decide what is published in St. Lucia, in the Gazette or elsewhere. And you may well complain, look, these laws apply to us and it's difficult for us to find out what they are. But the difficulty of finding out what they are can't affect whether the laws are in place or not. There's nothing inherently difficult about publishing the Defamation Act in the Gazette, is there?
Well, my lady, that's really not our case at all.
No.
Our case is that if the St. Lucian Parliament of today decides to incorporate a specific act, including the 2013 Act, it would have to do so by a specific piece of legislation, and for that legislation...
Well, where do you get that from? Which provision in the Constitution says that it can only do it by specific legislation and it can't do it by a general provision? What in the Constitution stops Parliament making a general law that the law of England shall apply unless contradicted by any other statute?
Well, our complaint post-independence would be that creates a great deal of uncertainty.
But what is in the Constitution that stops it? Because your argument is a constitutional one, that it can't be done under the Constitution. So which provision says that?
Well, there's no provision that says it must be a specific act or one of general application.
Well, where do you get that from then?
Well, merely because the precedence of the past has been that our parliaments have incorporated specific acts, and that there's a question of certainty and accessibility to the law. To have a law that says the laws of England, generally speaking, shall apply in relation to something without it being more specific for the people of St. Lucia or the OECS to understand what really is the law that governs their rights and things.
Well, I understand that as a general complaint, but either it has a legal basis for that complaint or it doesn't. And what is the legal basis for it, if it has one?
Well, Parliament must act in a manner that makes the certainty of the law clear to the people of the country. That's the only response that I have.
Yes.
So that's where we are. How then do we move forward on the constitutional question? We have given, in summary, our constitutional argument. We have made written submissions. We have relied on judge statements by the Chief Justice in Doyle and Dean and by the High Court judge about certainty of the law. The law ought to be certain and accessible to the people of St. Lucia, where they can go to the Gazette, get the copy of the Gazette and know precisely what the law which governs them. My Lord, the last issue that I wanted to deal with is the question of, in the further alternative, whether there's any inconsistency between the Defamation Act of 2013 and the code. In this regard, we rely on the judgment of the learned trial judge. I'm trying to find out. The learned trial judge in his judgment, when he ruled, contrary to what, although overruled by the Court of Appeal, that the code was clearly inconsistent with the Defamation Act of the United Kingdom was clearly inconsistent with the code. If I may just go back to the code very quickly.
I think this is his paragraphs 45 and 46. Is that right?
Yes, indeed, indeed. And
have we got the prescription period? He first of all talks about a prescription period laid down in
page 981.
Article 2123 of the code. Have we actually got that in the bundle?
Yes, it's at page 981.
981, thank you.
If I may just very quickly go through we rely on the judgment, but I just wanted to point out in the bundle where some of the provisions are. At Article 9894 9898 is the provision that says it is not necessary to allege or prove special damage. The Defamation Act specifically requires the obligation to prove damage. 989K concerns the justification. 989L, fair comment. 989M and N, various privileges that exist in St. Lucia under the code. 989Q that provides for consolidation of cases if the complaint was very similar and so on. So we respectfully submit that the Court of Appeal was wrong to hold that there was no inconsistency with the Act and that the learned judge was correct for the reasons which he gave in the paragraphs referred to by your Lordship.
Well, is there anything in the Civil Code that is inconsistent with the single publication rule that has been brought in by Section 8 of the 2013 Act?
I think the judge referred to it as a common law rule.
Mm-hmm. In that case, subject to your constitutional point, it has now no longer the law of England, and there's nothing inconsistent with it in the law of St. Lucia, is there?
Well, I'm not aware of any specific provision in the code, unless my team in St. Lucia could guide me to it.
As I understood what you were saying, Mr. Astafan, we have to interpret the provisions in relation to libel and slander against the common law. What one subsequently had, it might be said, is a position where the law of England has changed so that the common law no longer applies. But it doesn't change the common law. It just means that for the purposes of England, what was the common law is no longer applicable. Is that your submission?
My Lord, our submission is that the code, having codified the common law defenses of justification and fair comment. I took the point earlier on from His Lordship about no definition in the code. And it was one of the exceptions to the Vagliano principles that one could look at what the law was in order to get a meaning of what justification is.
So on your submission, the single publication rule is still part of the code in St. Lucia?
No, it never was.
Because the common law has to be taken into account when one's interpreting the code as laid down. Is that correct?
You mean the multiple publication rule?
But yes, sorry, multiple publication rule, beg your pardon, yeah.
I am not aware, unless my learned friends in St. Lucia. Could you bear with me? May I have 1 minute, my Lord, please?
Yes, sorry, I've confused the matter. The multiple publication rule was the common law, yeah.
I think that's the position, unless I'm told.
Can you just help us with which of this matters? Because why does it matter, these arguments? I mean, for example, justification, there's hardly any difference between the common law and the 2013 Act. I'm surmising that what might make a difference is that whether there's a single publication rule or not in this case. But can you just help us with why it matters which regime applies? Why does it make a blind bit of difference to Mr. Hilaire?
Well, my Lord, simply based on the law as we understood it, we submitted and we maintained that there were inconsistencies that prevented the wholesale application of the Defamation Act of 2013.
Yes. And why does that make any difference to your client's case, whether he's got the Defamation Act or the old law? Why is it going to matter to whether he wins or loses?
Well, it may not make a difference whether he wins or loses, but the law The law did change, and there were changes made under the 2013 Act that clearly conflicted with the code.
Well, I hoped you were going to say it made some difference, that this appeal, and it wasn't just a purely academic interest.
No, it was not a matter of pure academic interest. It was a matter that needed to be resolved by the Privy Council because it had caused some uncertainty in the public of St. Lucia. And they needed to have the law clarified by the Privy Council, and that's one of the main reasons why we're here.
Well, that's very generous of your client to be bringing the proceedings for for the public good in that way.
When
The only
Mr.
fundamental difference, Mr. Astafan, that I can see is the serious harm rule. And I was just wondering, well, whether that conflicts with the Civil Code.
Well,
Which part of the Civil Code conflicts with the serious harm rule?
Yeah, that could make a difference.
Article 989H, they said it shall not be necessary to allege or prove special damage in certain cases.
Let's have a look at H, okay? Which page is that?
948.
Well, that's to do with special damage. And so, which part of the 2013 Act now requires there to be proof of special damage?
I think there may be a confusion here between the need to prove specific damage in some cases of slander, and the serious harm test introduced by Section 1 of the 2013 Act. As I understand it, the submission which is made on behalf of the appellant is that the law is changed as a result of Section 8. But for my part, I'm not sure that they're the same thing. Indeed, I don't think they are the same thing.
If you go to page 379 of the bundle, Mr. Astafan, you'll see paragraph 14 of the amended defence, which relies on Article 2123 and Section 8 of the Defamation Act to say that your client's cause of action is statute barred because the words complained of were first published in November 2015 or December 2015, and because of the new first publication rule, your claim, which was brought in March 2017, is more than a year after first publication. Now, is that not why this issue was thought to be of sufficient significance as to make it a preliminary issue to be heard at the early stage of the proceedings?
That would have been part of the reason, my lord, because they were applying the Limitation Act of the United Kingdom as opposed to the Limitation Act in the code.
That was a defence introduced by way of amendment by Mr. Chastanet, wasn't it?
Yes, my lady.
Yes. Well, Mr. Astafan, you've got a few minutes of your time left, about 2 or 3 minutes, if you'd like to bring your submissions to a conclusion.
May I just have a moment to consult with my colleagues in St.
Yes,
Lucia,
of course.
my lord?
Of course.
Whether we need to hear on the Constitution, is it worth deciding to just let them do with everything? Okay. Yeah. Yeah. Yes. Yeah. Sure.
My lord, my lady, I just wish to sum up.
Yes.
Our position on the interpretation of Section 917A. It is merely a matter of construction. 2, the constitutional question, simply on the premise that following independence, that a law ought not to be imported based on a decision made in 1956 as opposed to 1978 and following. and that we rely on the judge's ruling on the question of the inconsistency with the code.
Thank you very much. Thank you, Mr. Estefan.
Thank you.
Bear with me just a moment. Yes, Mr. Patterson.
Good afternoon, my lords, my lady. I'd like to start by addressing...
Mr. Patterson, can I say that at the moment we can hear you loud and clear, but we can't see you at the moment?
No, there we go.
On all the time. Let's start again. Are you able to see me now?
We can see you now. We can see you.
Yes.
And hear you. Thank you.
Good afternoon, my lords, my lady. I propose to rely largely on the written submissions that we filed, but I'd also like to expand on that in a bit. Your lordships asked the question whether or not Article 989F was included within the ambit of Article 917A. And it seems to me that it certainly was not included in that ambit, for the simple reason that Article 989F was among the articles introduced by Act 34 of 1956. 4 of 1956 introduced a number of provisions in the Civil Code. And the intention behind that was to change the focus. It represented what I would describe as a sea change to the applicable laws of St. Lucia. Prior to 1956, St. Lucia law was a mix of French law and English common law. In 1956, certainly as it related to contracts, torts, and other areas covered by the amendments introduced in 1956, there was a whole-scale introduction or importation of English law, statute law, and common law. And that's borne out by the fact that there are a number of sections of the code that, apart from Article 917A, that introduced the law of England. So, for example, my lads, we submitted a supplemental bundle which has the most recent revised code for St. Lucia. I don't know if your lordships have had an opportunity to see that revised bundle.
Is this recently submitted?
That was recently submitted.
Sent separately?
Is it called the supplemental authorities of the respondent, or
is it the Civil Code?
No, is it the Order in Council 1951? Oh, I don't know. A number of things.
So that was submitted last night. The supplemental bundle.
Yes, we have the Civil Code of St. Lucia, yes, revised edition as at the 31st of December 2020.
That's correct.
That's been supplied as a separate document.
Yeah.
Yes.
Before you develop the point, and while my colleagues find it, it's a separate document of 298 pages.
It's also in the supplemental authorities.
It's now in the supplemental authorities as well. Thank you. we know that 989F was introduced into the Civil Code in 1956. Do we know when 917A was introduced?
It was introduced in 1956 by the
At the same time.
Act.
Thank you.
Same Act 34 of 1956. You will see throughout the code there are references to Act 34 of 1956, added by Act 34. And it's in parentheses at the bottom.
Yes.
So you will see, for example, if you go to page Article 916A.
916A.
A.
That's the property and trusts one.
Trust, that's correct.
And what's the page number of that in the supplementary bundle?
122. At paragraph 4, you'll see whenever the law of England of a beneficiary of a trust. Paragraph 2 says implied constructive resulting trust shall arise under the law of St. Lucia in the same circumstances as they arise under the law of England. And paragraph 4, again, in reference to law of England. I'm just going to highlight some of the examples. Article 1608A, which appears at 190 of the bundle. This was also added by the same Act 34 of 1956.
Forgive me, 916A was 1956.
1608.
Yes, I know, but my question relates to the previous one, 916A. That was 1956.
It was added by the same Act of 1956.
Yes, thank you very much. Now we're going to 1608A at page 190.
Yes. Subject to the provisions of this code or any other statute, the law of England for the time being relating to contract of agency shall apply. You'll see in parentheses added by Act 34 of 1956. It's the same act.
Yes.
If you go to 1137, Article 1137, that's on page 153.
Sorry, page?
153, the supplemental bundle.
Thank you.
You'll see that, again, the law of evidence, rules of evidence, established in the law by the law of England, added by Act 34 of 1956. Yes. There are 17 instances in all where the law of England is imported by virtue of Act 34 of 1956. Article 917A was one such instance, but these others were all added by Act 34 of 1956. And I say this is important because the submissions of counsel for the appellant will have if they're correct, will have far-reaching impact in St. Lucia, because it is not just affecting Article 917A, but it will have impact on each occasion where in 1956, the colonial legislature used the mechanism of the general importation of English law. So you're dealing with trust, agency, evidence. These are all instances where 1956, by the same enactment, Act 34 of 1956, English law was imported by general application. That's important, again, because if my learned friend is correct, then you're going to erase all that law over all the jurisprudence and law over the last 67 years since this provision was enacted, and an entire vacuum complete vacuum as to what those relevant laws are. If they are no longer, if these areas of law are no longer covered by English law, what will be the applicable law to which you turn? Law of trust, for example, was imported by Article 916A. What would be the applicable law if all of this law is suddenly erased? The other point that needs to be made is that Article 917A, as it relates to contracts and torts, was intended to bring a sea change in those specific legal areas, because up until 1956, if we stick with defamation as a specific area of law, the tort of defamation was virtually non-existent. It was the tort, the cause of action of libel and slander existed under French law, but in a very limited context, and was significantly different to the common law of England on defamation. So the introduction of these specific provisions, Articles 9, 8, 9F, and onwards, relating to libel, those provisions were introduced for the first time by Act 34 of 1956, the same act that introduced 917A. So if you go to 989F, which is at page 132 of the supplemental bundle, you'll see it makes reference to the law of libel and slander added by Act 34 of 1956. 989G added by Act 34 of 1956. And if you can search throughout the code, and the only references to libel and slander appear in the sections that were added, the articles that were added by Act 34 of 1956. And that's important for two reasons. One, it's important because it introduced for the first time statutory provisions relating to libel and slander, which did not exist before 1956. And these are all provisions that relate to the English common law cause of action of defamation, libel and slander. It's also important to understand the effect of 917A, or the purport of 917A. And if you go back to 917A, it's specific. It says the provisions of Articles 918 to 989 stops at 989. It doesn't say 989 A, B, C, D, E, F. It stops at 989 because A to F, the provisions that follow that were introduced in 1989, were all these provisions relating to the common law of tort and contract. And therefore, it was unnecessary to provide that the code shall, as far as practicable, be construed accordingly in relation to those provisions that were being introduced in 1956. Articles 9189 to 989 existed in the code prior to 1956. 989A, B, C, D, E, F, G. Those were all added in 1956, at the time that there was this wide-scale importation of English law. And the reason the article, paragraph 1 of 917A then continues to say, the said articles referring to 918 to 989 and 991 to 1132, the said articles shall cease to be construed in accordance with French law. Because prior to that amendment, those articles would be construed according to French law. The sea change introduced by Act 34 of 1956 was meant to move away from French law, which was a ceded law at the time. St. Lucia was ceded to England in 1856, I believe it was.
So can I just be clear, Mr. Patterson, about what you are telling us the law in St. Lucia was prior to 1956 in respect of libel and slander? I think Mr. Astafan told us that it was the common law, as I understood him to mean the common law of England, but I'm not sure what are you saying the position was at that time?
It was French law, because the code was to be interpreted in accordance with French law up until 1956. And the French law, as it related to defamation, was in fact entirely different to English common law.
And do you accept that the civil code at that stage, based on French law, was intended to be comprehensive?
It was not. In my view, the civil code had a passing reference. If you look in the civil code, you will see that the only reference to libel appears in the table of contents prior to 1956. There's a reference in the table of contents, or the index rather, I should say, at page references to Article 985. When you go to Article 985, it's at page 275 of the supplemental bundle. You will see in the index libel 985, 989F, etc. If you go to 985,
What page, sorry?
it deals with negligence.
Oh, I see.
Doesn't mention libel at all.
What page?
And the law of responsibility.
The supplementary bundle.
Yeah.
127.
It's in the supplemental bundle.
127.
Yes, page 127, Mr. Patterson. Thank you. That's
Page 128. Says every person capable of discerning right from wrong is responsible for damage caused either by his act, imprudence, neglect, want of skill, and he or she is not received. That was the only reference to libel.
But wasn't it in the Article 2123, which set the limitation period? Was that also introduced in 1956, or did that predate the 1956 changes?
I believe that predated it.
So what was it that seemed to contemplate that there was an action for libel and slander if it's setting a limitation period for it?
Well, I'm seeing where it says here it was amended by Act 34 of 1956. So if you go to Act 2123.
Sorry, can just before we move to that, I'm just looking at, as I understood it, you're saying that 985, that article, was regarded as a reference to libel and slander. Did I get that correct?
In the index, it says it's a reference to libel, but it fell within the general rubric of responsibility.
So this is a typical civilian provision at a very high level of generality, which is why I'm surprised that you say that the code was not comprehensive. One would normally understand a civilian code by definition to be comprehensive, and they have these sort of provisions at a very high level of generality. So isn't that the case that Article 985 is a reference to libel and slander?
Indirectly, in general terms. So there's no express exposition of the cause of action of libel and slander. That was only introduced, the express reference to libel and slander, that was only introduced in 1956 by Act 34. And the provisions, all the provisions in the code that refer to libel and slander were added by Act 34 in 1956. And those provisions, when you look at them, those provisions do not, contrary to what my learned friend asserts, do not represent a comprehensive code on the tort of defamation. They certainly do not. In order to understand the tort of defamation, one could not confine oneself to the provisions of the code that were added in 1934. You still had to refer to the common law.
So they were intended to supplement the common law, is that right?
They were intended to supplement in the same way. So when you look at the provisions that were added in 1956, 989F, for example, those provisions were almost identical to the 1952 Defamation Act, introduced the same provisions that were introduced in the UK by the 1952 Defamation Act. We make that point in our submissions at paragraph, these points are all covered in our written submissions in paragraph, from paragraph 88 onwards at page 709 of the electronic bundle.
Yes. So in
In fact, if you
1950,
start from paragraph 85.
as I understand it, Mr. Patterson, what you're telling us is that in 1956, there was a fundamental shift from a civilian French approach, if you like, to an English common law approach.
That's
and
correct.
That means that when one has within the provisions words like justification in the context of libel and slander, we must interpret that against the common law of England in order to make sense of it. Is that correct?
That's correct. That is correct, precisely so. Because those concepts did not exist in French law. These are all common law concepts. There's in fact a case, my lords and my lady, that I had stumbled across in my preparation for this matter this morning, which touches exactly on this point about French law. It's a citation. The citation, it's a Canadian case. Giles E. Neuron Communications Marketing Inc. versus, I don't speak French, Chambre des Notaires de Quebec, 2004 SCJ number 50. It's a decision of the Supreme Court of Canada, a 2004 decision, but it dealt with the cause of action for defamation under French law.
Do we have this authority, Mr. Patterson?
I do have it.
We don't have it in the bundle, do we?
No, it's not in the bundle because it only arose in the discussion.
Right. Can I ask you to repeat the name slowly, please, so we can make a note?
And can he send it?
It is.
And indeed, can you then send us a copy of the? Can you then send us a copy of it?
And then I will send it to you.
But the name, please.
The name is GILLES, Gilles E. NERON, Communication Marketing Inc. versus CHAMBRE DESNOTAIRES de Quebec. The citation is 2004 SCJ number 50.
Thank you.
And the relevant passage appears at paragraph 56. And if I may be permitted to just read very quickly what was said by the Supreme Court in Quebec. An action in defamation is grounded in Article 1457 CCQ. Like any other action in civil, delictual, and quasi-delictual liability, the plaintiff must establish on the balance of probabilities the existence of injury, a wrongful act, and a causal connection between the two. The starting point is not the common law, but the Civil Code of Quebec, which is the basic general law in Quebec as provided for in the preliminary provision of the Civil Code. Courts should avoid needlessly importing or applying common law rules in a matter which, subject to the principles of charter law, is governed by the procedure, methods, and principles of the civil law. This point was made in the context of the law of defamation by J.L. Bowden and P.S. Delors in a text, the translation of which is, it can be seen from the leading cases how often the Quebec courts have, when dealing with defamation and verbal abuse, borrowed from common law concepts, good faith and justification, qualified privilege, from decisions of English or Canadian courts, or from common law commentators such as Odgers. Borrowing from the common law in this manner is totally unnecessary and unwarranted, and it has the effect of greatly complicating a subject that, when examined in light of the Civil Code and the general principles of civil law, has the merit of being relatively straightforward. And they go on to discuss the existence of injury and so on. This passage that I just read is important because it sets the context in which the cause of action in defamation arose prior to 1956. It was an entirely civil law concept. The sea change represented by Act 34 of 1956 dispensed with the Civil Code, the civil law cause of action, and introduced for the first time in St. Lucia the common law cause of action of defamation. And to the extent that there are statutory provisions that were introduced by Act 34 relating to defamation, those statutory provisions were meant to be applied in conjunction with the English common law. And Article 917A declared not just that those provisions should, those statutory provisions should apply, but also the law of England for the time being should apply. So that the law of England for the time being, as we argue, was not just the law that existed in 1956, but the term for the time being is ambulatory, and therefore it introduced any statutory changes, imported statutes of England that were passed from time to time relating to contracts, torts, and quasi-torts.
So were paragraphs 989 and following, 989F and following, intended to reflect the provisions of the Defamation Act 1952?
That's correct. That's my interpretation.
Right, thank you.
Was there any adaptation of them in order to fit in with the position in St. Lucia?
There was no adaptation. In fact, the language was almost identical. I think it was identical.
Why did they need then to have them if they were importing the 1952 Defamation Act?
So in my view, it introduced in statutory form the 1952 Act with the intention that as further statutes were passed in England, those statutes would also be introduced to supplement the provisions that existed in 1956.
Can I just be clear, Mr. Patterson, that once the 1956 reform had been made, there was then, on your submission, a fully comprehensive and coherent law of libel and slander in St. Lucia, which was the English common law plus the reforms made in 1956, or perhaps I'll put it another way, the reforms made in 1956 interpreted against the common law of England. That was a comprehensive, coherent scheme.
That's my understanding, that for the law of defamation, you would refer to the civil code as well as the English common law. And from 1956 onwards, you will also incorporate any changes in the common law in England and any statutory changes introduced by the UK Parliament.
But as I understand it, you're nevertheless saying that those statutory amendments are not a comprehensive code.
They're not a comprehensive code.
Yes, thank you.
Because you will not find in them a statement of, for example, what is the tort of defamation? What does defamation consist of? What are the defenses to defamation? Justification. You will not find a statement in the code as to what that defense consists of.
Thank you.
Was there any, can you discern any logic behind the choice of the articles which are specifically mentioned? 918 to 989 and 991 to 1132. It looks as if someone has carefully chosen those, and I wondered if you, knowing the code, can identify why those and not others were chosen, because there probably are some excluded which pre-existed the 1956 Act, but which were not included in that sub-part of 917A.
Because prior to the introduction of the 1956 Act, the topic of contracts, quasi-contracts, and torts would have been covered in part by Articles 918 to 989 and 991 to 1132 of the Code. Those were existing provisions relating to contracts, quasi-contracts, and torts. Those provisions were supplemented by the articles that were added by Act 34 of 1956. so that the comprehensive, the code was augmented in 1956 to introduce the common law position in England, was augmented to introduce the statutory position in England as it related to contracts, quasi-contracts, and torts. So it didn't just cover the area of defamation. It covered the law relating to contracts. It covered the law relating to quasi-contracts and torts. And those provisions were introduced by Act 34 of 1956.
Can I ask you this, Mr. Patterson? If we now were to accept that the 2013 Defamation Act is applicable in St. Lucia, what impact does that have on the Articles 989F to 989S? In other words, what was previously the law as set out in the code on libel and slander? Does all that disappear? Or do we have to go, well, what's your answer to that?
In my view, they become, to the extent that the common law position is abolished in England by virtue of the 2013 Act, and that those specific articles in the code related to the common law defenses, then those articles are no longer relevant. They become OTOs, redundant. My learned friend says it means they are repealed. There's no such thing. An English act cannot repeal a provision of the code, but it does render it OTOs, redundant.
So we have both alongside each other. Is that what you're saying?
No, what I'm saying is, to the extent that the changes introduced by the 2013 Act would have affected the common law position in the UK. So let's start from the position that the defamation law consisted of common law principles and statutory provisions in the UK and to some extent in St. Lucia. In St. Lucia, the statutory provisions were embodied in the code from Articles 989F and onwards to 989S. Those provisions were embodied in the code, but to understand the tort of defamation, you also had to resort to common law principles. And when the law was changed in England, then you had in 1952, 1996, and 2013, those are the three defamation acts in England.
And 1996.
I'm sorry, 1952, 1996, and 2013. Those are the three defamation acts. So the 1996 Defamation Act would have extended to St. Lucia by virtue of Article 917A, and the changes introduced by that act would have been incorporated as part of St. Lucia law. And 2013, we're saying, also amended the law relating to defamation as applied by that act, so that the common law position that obtained prior to the 2013 Act would have changed by virtue of the 2013 Act, and to the extent that the common law was changed, and the provisions in the Civil Code that related to those common law defenses would become redundant, because the common law defense of justification was replaced by the statutory defense of truth.
But the argument against that, Mr. Patterson, seems to me to be that Section 989K, to take that example, recognises there being a defence of justification, which is then not going to fail for certain reasons. It must surely be inconsistent with that to abolish the defence of justification. I mean, the reality is that if you do that, it wouldn't have made sense to continue the 1952 Act in England when the 2013 Act came along.
That's correct. And so in England, the 2013 Act abolished the defense of justification. It also abolished the defense of fair comment.
Yes.
And to the extent that those were common law defenses and not covered by the code, there could be no inconsistency between the 2013 Act.
But might you not construe 989K as recognising a defence of justification, albeit adjusting it? And it is inconsistent with recognising a defence of justification to abolish a defence of justification.
So I understand that argument. And my answer to that is simple. Up until 2013, there existed in St. Lucia a common law defense of justification. And that common law defense of justification existed not by virtue of the code, because it's nowhere stated in the code. The principles relating to the defense of justification are nowhere articulated in the code. There were common law principles. And therefore, up until 2013, those common law principles relating to justification form part of the law of St. Lucia by virtue of Article 917A. It was extended, those common law principles, those common law defenses were extended to St. Lucia by virtue of Article 917A. When in 2013, the 2013 Act, Defamation Act, abolished the common law defense, it had the effect of abolishing also the common law defense as it then existed in St. Lucia. It is a common law defense.
So you're saying that the common law defence only existed in St. Lucia by virtue of being incorporated by Article 917A, and 917A can giveth and taketh away, and that once the Defamation Act took it away, it was no longer incorporated by virtue of 917A, but the new Act was. Is that your case?
That's exactly the position. And so to the extent that Article 917A says that the common law of England for the time being, that being ambulatory, the law of England for the time being, which represented in relation to defamation, the common law relating to defamation, and the enactments, the 1952, the 1996, and the 2013 Acts, the 2013 statutes, that is where you will look to find the law of defamation, the common law and the statutory provisions. In 2013, the common law defenses of fair comment, justification, those defenses were abolished. And so if you apply 917A, it means that the common law defenses, having been abolished, then the provisions of the code that related to those defenses, and I make the distinction when I say related to those defenses, the provisions of the code which extended the common law principles relating to the common law defenses of justification and fair comment. Those provisions, those specific provisions, 989K and 989L, became redundant because there no longer existed in St. Lucia a common law defense of fair comment.
There's a certain chicken and egg thing about the argument, because it's only abolished the defence of justification if it's not inconsistent with 989K.
No, with all due respect, that's not correct. 917A speaks, 917A paragraph 3
Yes.
speaks to a conflict between the law of England and the express provisions of this code. And it does not cover a conflict between the law of England and the common law in St. Lucia. So it is only where there's a conflict between the law of England and express provisions of the code.
Yes, but the argument against you is that it is a conflict with a provision of the code which recognises a defence of justification to abolish a defence of justification.
Except that the provision of the code that recognizes the defense of justification only applies to the common law defense of justification. There's no provision of the code that creates that defense.
So
It is a common law principle. It exists as a common law defense. It doesn't exist by virtue of any.
So, Mr. Patterson, if 989K had within it, after the words a defence of justification, open brackets, which this code recognises to exist, close brackets, that would make all the difference, would it?
I'm not sure that it would, because you will not find anywhere in the code an expression of what that defense is. A defense of justification is not articulated anywhere within the code. And that's why we say the Vagliano principles can't apply, because the code is not a comprehensive code relating to the law of defamation. It's not comprehensive because the law of defamation up until 2013 was largely a mix of common law and statutory principles. And the defenses of justification, fair comment, and so on, those were common law defenses. They were never codified in St. Lucia.
So you're saying that the reference to the common law defence of justification in 989K did not in any way entrench that defence in the code so as to prevent it from being abolished under the ordinary operation of 917A1 if it was abolished in the common law and so would no longer be incorporated in.
That's my view, because if you look at the way the 2013 Act operated in relation to sections 5 and 6 of the 1952 Act, it operates precisely the same way. In the sections 5 and 6 of the 1952 Act would have been introduced as an overlay on the common law defenses. It extended the principles, the common law principles. In 2013, when the 2013 Act abolished the defenses of justification and fair comment, the effect of that was to render the 1952 provisions redundant. And so in recognition of it, those provisions were specifically, the 1952 provisions were specifically abolished by the 2013 Act, repealed by the 2013 Act. And so the operation works precisely the same way in relation to St. Lucia law as it relates to the common law defenses, because the effect of the 2013 Act would be to render Articles 989K and 989L, it renders them redundant because there's no common law defense to which they would apply. It ceased to apply. The common law defenses cease to apply. If you apply Article 917A, if you apply Article 917A in strict adherence to the language of 917A, and if you accept that it is effective to import statute law and the common law of England, then it means that it imported the 2013 Defamation Act. If it imported the 2013 Defamation Act, then the 2013 Defamation Act abolished the common law defenses and replaced them with statutory defenses. And so that operation occurs in St. Lucia as well, because up until that time, it was the 2013, up until that time, it was the common law defenses that existed in St. Lucia. The 2013 Act abolished the common law defenses, and it therefore rendered redundant Articles 989K and 989L, which related to those common law defenses. Did not establish those common law defenses, but related to them. And so the 2013 Act, having abolished the common law defenses, they no longer form part of St. Lucia law. So what you had left is these provisions, 989K and 989L, which were intended or meant to apply to a common law defense, but that common law defense has been abolished. Therefore, they're left hanging, they're stranded, they're orphans, they're redundant.
And does it make any practical difference, this? Is there any relevant difference between justification and truth as a defense that matters for this case?
There are none, but there is a difference, as you correctly pointed out, in relation to the limitation point. So the single publication rule versus the multiple publication rule, I think that's important. We have relied on the single publication rule as part of our defense to say that some elements of their claim would be statute barred because they don't rely only on the first publication, but also subsequent publications. And we're saying those subsequent publications are barred by virtue of the single publication rule, which was introduced by the 2013 Act.
And would that apply, would that depend upon knowledge of the earlier publications, or is it absolutely quite clear that they are barred?
We say it applies the single publication rule as articulated in the 2013 Act, with the one exception, with its important exception being that the 2013 Act speaks to a limitation period under the Limitation Act of 1980, which doesn't apply to us. The relevant limitation period is the Article 2123, which is set out in the code. And therefore, when you read it, mutatis mutandis, that provision would read, for the purposes of Article 2123, and then you look at 2123 to see what that says.
So you rely on the Court of Appeal's revision or rewriting of 2123 in accordance with Section 8 of the Defamation Act?
That's correct. The Court of Appeal accepted our arguments that you would apply the Section 8 of the 2013 Act, mutatis mutandis, and therefore you would have to read into Section 8 the language that is set out in the code, Article 2123, relating to the limitation period for libel and slander.
So the result would be that time would run from first knowledge.
First knowledge, that's correct.
Thank you.
Can I ask you, Mr. Patterson, you've taken us to the latest version, I think, of the Civil Code. That's December the 31st, 2020. And we see within that there have been all sorts of revisions made over the course of a number of years. I suppose the question might be, given the uncertainty raised by this question, why wouldn't the preferable approach be to say, well, if you want the 2013 Defamation Act, amend the Civil Code as one has done many years in the past?
Answer to that is simple. If you look at 917A, if you go to 917A in that revised code, it's at page 917, it's at page 123. Look at the language. You'll see it says, subject to the provisions of this article, from and after the coming into operation of this article, the law of England for the time being relating to contracts, quasi-contracts and torts shall mutatis mutandis extend to St. Lucia. And I pause there because the words St. Lucia were not included in the original formulation. In the formulation, the colonial statute said, this colony.
Yes.
So when you look at the first page of the Civil Code, you will see the description, revised edition, showing the law as at 31st December 2020. This is a revised edition of the law prepared by the Law Revision Commissioner under the authority of the revised edition of the Laws Act. And it shows all the statutory changes to the code from inception, amended by Law 9189 edition, 1996, and so on. You'll see among them 34 of 1956. And then followed a number of amendments all the way to 2014. And the point I make is this, that the inclusion of the continued inclusion in the code of 917A is not accidental. It is deliberate. That if Parliament wanted to change post-independence, if since 1979, if after the independence of St. Lucia, Parliament, the new Parliament, the existing Parliament, wanted to change 917A, it had every opportunity to do so. And in fact, it did. Because the original language which spoke to the colony was updated in the revised editions to speak to St. Lucia. Therefore, one must read into it that there was a deliberate intention of Parliament to retain 917A as enacted originally as part of the law of St. Lucia.
Did Parliament actually play any role in changing that word?
I don't think it would have. It would have been done pursuant to the law, the powers vested in the Law Revision Commission.
Yes.
Under the revised edition of the Laws Act. But the point I make is twofold. And when you look at the decision in Ibralel, you'll see why it's an important point. That it's been 67 years since the 1956 amendments were introduced to the code. It's been 44 years since St. Lucia became independent. And it even goes before that. St. Lucia became an associated state, which was virtually independent since 1967. And so when you look at these amendments to the code within that context, you'll see that certainly Parliament had every opportunity to remove from the language what my learned friend describes as this offensive position, where you're introducing laws of another country into a sovereign St. Lucia. And the appellant's position rests heavily on this notion of sovereignty. And it is our position that sovereignty is not implicated in this case at all, because the argument of the appellant, and if I might segue into the constitutional point, the argument of the appellant rests on the fallacious notion that Article 917A somehow is offensive to the concept of sovereignty in St. Lucia. The Parliament of St. Lucia, under Section 40, has the power to make laws for the peace, order, and good government of St. Lucia, and that it is offensive that Article 917A would have the effect of importing laws from England, and that it impinges on the sovereignty of St. Lucia. Well, Article 917A was introduced by the Legislative Council of St. Lucia. It was a representative legislature, meaning comprised of more than 50% comprised by elected members. And all the case law that we've included in our submissions will point to the fact that that legislative council had plenary powers appropriate to a sovereign. The fact that it was a colonial legislature is of no significance. It had the plenary powers appropriate to a sovereign. That's Ibraleb, that's the Bureau case, a number of cases that decide that, a number of decisions of this House, of this court, that says that a representative legislature, colonial legislature, that's a representative body, had all the powers by virtue of provision, the section that conferred on it, power to make laws for the peace, order, and good government of St. Lucia. That legislative body, the legislature, the colonial legislature, had the powers of a sovereign. It was almost as if it were the UK Parliament, the Imperial Parliament, that passed that law. But it was still sovereign St. Lucia. And therefore, those powers were replicated in the legislature established under the 1967 Constitution, and again replicated when the 1967 Constitution was replaced by the 1979 Constitution. It's identical power, the same power to make laws. It's a formula that's used throughout the Commonwealth, where the legislative body is empowered to make laws for the peace, order, and good government. If you look at the decision in Ibraleb, it speaks specifically to the extent of that power. It's at paragraph 4 of our written submissions that appears at 685 of the bundle, electronic bundle, 685. You'll see that the St. Lucia Legislative Council Order in Council provided at section 17, and a copy of it is in the bundle, that the governor, with the advice and consent of the Legislative Council, had the power to make laws for the peace, order, and good government of St. Lucia. It's the same formulation that currently appears in the section 40 of the Constitution. And the appellant's argument proceeded on the basis that Article 917A was enacted by a colonial legislature, and somehow that colonial legislature had no, as I understand the argument, had no power to bind the existing parliament, and that the provision introduced by the colonial legislature is inconsistent with the power that is conferred on Parliament under the current Constitution. But it disregards, in our view, the argument disregards the status of that colonial nature and the plenary powers that it exercised pursuant to the law. And the cases of R.V. Bura and Ibrahim illustrate that, as well as the case of Christian. If you go to page 1639 of the electronic bundle, the relevant passage starts.
Which case is this Christian?
This is Bura, R.V. Bura. I'll just take you to the relevant passage. There, at the bottom of page 1639, starting, but their lordships are of the opinion that the doctrine of the majority of the courts is erroneous, and it rests upon the mistaken view that the powers of the Indian legislature, indeed of the nature and principles of legislation, Indian legislature has powers expressly limited by the Act of the Imperial Parliament, which created it, and it can, of course, do nothing beyond the limits which circumscribe these powers. But when acting within those limits, is not in any sense an agent or delegate of the Imperial Parliament, but was intended to have plenary powers of legislation as large and of the same nature as those of the Parliament itself. And those principles were expanded on in Ibrahim, where the court said that the Ibrahim is at page 1299 of the bundle. At the top of the page, they refer to the power to make laws for the peace, order, and good government of Ceylon. The words peace, order, and good government connote in British constitutional language the widest lawmaking powers appropriate to a sovereign. And if you go to the Christian, I mean, this principle is well established, and page 1645, R versus Christian.
1645.
1645.
Thank you.
Top of the page, paragraph 4. The submission that the governor had acted ultra vires in enacting an ordinances concerning legal aid, sentencing, parole, etc. The argument was without merit. The governor acted in accordance with his mandate to legislate for the peace, order, and good government of Pitcairn, a phrase which connoted the widest lawmaking powers appropriate to a sovereign, and the ordinances were clearly within his powers. So if you extrapolate that argument, the point is that the colonial legislature was effectively exercising powers appropriate to a sovereign St. Lucia. Those powers were the identical powers that were conferred on the legislature by the 1967 Constitution and by the current Parliament by the 1979 Constitution. And the question was posed to my learned friend earlier, would there be any objection if the identical Article 917A was enacted today by the current Parliament? Would there be any objection in principle? And the answer has to be no, because the method of importing foreign statute, English statute, is a well-established method that has been recognized and accepted by the courts, by this honorable court, on numerous occasions. And therefore, the principle that a sovereign nation could import the laws of another country as incorporated as part of its law, it's not a novel concept. It's well established, it's well recognized. And the parliament, whether it is this parliament or the parliament that existed under the 1967 constitution, or the legislative council that existed prior to the while St. Lucia was a colony, it makes no difference. It is the act of a sovereign making a conscious decision in the exercise of powers that it undoubtedly has to import or incorporate the laws of another territory into the laws of St. Lucia. If they had said the laws of the United States of America relating to defamation shall apply, there could be no objection to it if the current parliament enacted those laws, because it clearly has the power to do so. There's nothing in the Constitution that prevents it from doing so. And so long as it does so in accordance with the lawmaking, in accordance with the limits as imposed by the source of its power, in this case, the Constitution, in the case of the in the case of the predecessor Legislative Council, under the St. Lucia Legislative Council, Order in Council, that was the source. As long as it was enacted in accordance with the source of that power, then it was free within those limits to enact any law. So that there's no argument being advanced by counsel on the other side that at the time that the 1956 amendments were introduced, that the Legislative Council had no power to do so. They have not advanced that argument. The law was introduced validly. It remained a valid part of St. Lucia law in 1967 when St. Lucia ceased to be a colony and became an associated state. It remained as part of St. Lucia law in 1979 when St. Lucia became fully independent. It remains part of the law today. And if you follow the argument of the appellant, they're saying, notwithstanding that it was an existing law up until 1979, that it should now be invalidated by this court because that law is inconsistent with Section 40 of the Constitution. And with the greatest respect, the argument does not follow, because the power that my learned friend is saying, the provision of the Constitution that Article 917A conflicts with is Section 40, the power to make laws for the peace, order, and good government. That Section 40 existed in the 1967 Constitution, Section 35, I believe it was. It also existed under the St. Lucia Legislative Council Order, Section 17. Same formulation, same language, identical power. So that if it was offensive, if it conflicted with Section 40, if it were to be passed today, the question is, would it represent an inconsistency with Section 40? The answer is no, because it would be made in accordance with powers conferred by Section 40, but not be in conflict with those powers. If the court accepts that a general provision for the importation of law by this means is permissible, then it could in no sense be inconsistent with the exercise of that power pursuant to provision of the Constitution. And this court, in fact, ruled on that point. If you go to paragraph 21 of our written submissions, and the cases that we cite prior to that, you'll see that this mechanism for importing laws is well accepted. And the Privy Council in Ibraleb said as much at page 1300 of the bundle, electronic bundle, 1300. No, in fact, that's not the correct page. Let me. Privy Council decision. It's at page 1043. Page 1043 of the electronic bundle, paragraph 38 of the decision in R.V. Christian. At paragraph 38, this court said, in the case of the Judicature Ordinance 1970, section 14 provided that the common law, the rules and equity of statute and the statutes of general application as enforced in and for England at the commencement of this ordinance were to be enforced in the island so far only as local circumstances permit. The earlier legislation made similar provision for the incorporation of the laws of England. Mr. Perry correctly, in my view, does not dispute that an incorporation by general reference of this nature is permissible. So, if this court accepts that the incorporation of English law by general reference is permissible, and that it is not inconsistent with the power generally to make laws for the peace, order, and good government of St. Lucia, then if that power could be exercised today, and it doesn't offend against the constitutional principle, then it was a valid exercise in 1956 when Articles 917A and others were introduced by the Act 34 of 1956. It was a valid exercise then, it would be a valid exercise today, and there simply is no inconsistency as argued by counsel. There's another point that I wanted to touch on this same constitutional point. And on the question of sovereignty, because it doesn't follow, the argument simply doesn't follow when you consider that this is not a situation where the 2013 Act is being imposed on St. Lucia by Her Majesty or His Majesty, Her Majesty at the time, by the Parliament of Westminster Parliament. It is not being imposed on St. Lucia pursuant to the powers of a sovereign to legislate for British overseas territories. The 2013 Act is imported by virtue of an act of the legislature of St. Lucia, exercising powers appropriate to a sovereign. It is not the imposition of law, the extension of law by act of the English Parliament. It is the importation of law by an act of the St. Lucia Parliament. And so if you look at it in that way, and you make the distinction between having an act imposed on you or you exercising an independent will, sovereign will, appropriate for a sovereign to incorporate the laws of another country, in this case England, then I can't see how that is inconsistent with the principle of sovereignty. Sovereign St. Lucia today could pass laws today saying that the law of England relating to whatever subject matter shall apply. It's an act of a sovereign St. Lucia. And it shouldn't matter that the act was done in 1956 by the then representative body, or whether it's done in 2023 by the current representative body. It is still representative of the will of the people of St. Lucia. So the argument, while it may have some political appeal, is not founded in law. It's not founded in legal principles, nor constitutional principles. The other point that I want to make is, I want to touch back on, is the opportunity that Parliament had to change the law. If it was offensive, as my learned friend supposes, then Parliament could at any time repeal Article 917A. We've seen all the changes that were introduced to the code, and none of them affected Article 917A, except to the extent that the revision was made to change the language from colony to St. Lucia. But if you look at the decision in Ibrahim, you will see where there's a reference to the changes that were made I take you to page 1300 of the electronic bundle. The discussion was about, it starts at page 1299. At the bottom of that page, where this court was considering the effect of Ceylon's in the attainment of independence. In that case, Ibrahim, the Chief Justice, had held that there was no jurisdiction to appeal to the Privy Council once the Ceylon had attained independence. And in rejecting the argument, the court had said, well, there's nothing about attaining independence that changes the corpus of law. And we've argued the same thing, and the court in this case has found that there was nothing in the new constitution that changed the body of law, the existing law before.
The passage in question, Mr. Patterson, is it on page 1300?
It starts, the statement is made before that, about the corpus of law. But I wanted to take your lordships to another statement that was made by the court. If I might just find a relevant passage.
sentence on the second paragraph of page 1300.
Second paragraph of?
1300.
1300.
Thank you.
Is that the one to which you're referring, Mr. Patterson?
The second paragraph, the simplification. I wanted to speak to that, but there was, before I got to that, there was a passage that I'm trying to find. Just forgive me, I had it here before. Let me take you there. I'm not finding it. Well,
I think that
if we start at the bottom of, if we start at the bottom of page 1299, the last passage, paragraph there.
1299.
1299, the court summarized the argument that was being advanced. It then went on to say at the second paragraph, their lordships on 1300, first paragraph on page 1300, their lordships must observe in conclusion, having regard to two remarks that appear in the judgment of the Chief Justice, that it seems to be a misleading simplification to speak of the continuance of Privy Council appeal as being inherently inconsistent with Ceylon's status as an independent territory, or as being bound up with a relationship between Her Majesty and colonial subjects. Historically, the assumption would be in itself inaccurate, and constitutionally, it is unnecessary for it, if it is recognized as it must be, that the legislative competence of the Parliament of Ceylon includes power at any time, if it thinks right, to modify or terminate Privy Council appeal from its courts. True independence is not in any way compromised by the continuance of that appeal unless and until the sovereign legislative body decides to end it. If we apply those words to our situation, there's nothing inconsistent with the notion of sovereignty. If the power to repeal Article 917A exists and is exercisable by Parliament at any time, Parliament could tomorrow pass a law saying Article 917A is repealed. And that would be consistent with the sovereignty of Parliament. It is not inconsistent with that sovereignty to have a provision which incorporates by general provision the laws of England. It's not inconsistent. In fact, it is a somewhat ironic argument that the appellant is complaining about the sovereignty of St. Lucia being infringed while appealing to one of Her Majesty's courts. Parliament of St. Lucia has had every opportunity to repeal the provisions of law that allow for appeals to the Privy Council and to appeal directly to the CCJ. But incorporate the CCJ as part of it. It hasn't done so.
Mr. Patterson,
So
we're going to have to draw your remarks to a close now, I'm afraid. We're running out of time.
I will try to summarize. My lords, I've attempted to touch on it in the very short time that we've had. I've attempted to touch on some of the major points. And I think the critical thing is that in order for the appellant to succeed, they must show that there was this inconsistency. And there are some authorities that we've cited related to the 1967 Constitution and the effect of the Article 917A being retained subsequent to the passage of the 1967 Constitution, when St. Lucia attained associate statehood. What is the effect of that? We are saying that if Article 917A survived the provisions of the 1967 Constitution, which contains similar existing law provisions, then it means that it was an existing law in 1967. If it's an existing law today, then it is a recognition that it was valid under the 1967 Constitution. A learned friend's argument is that it is an existing law that is impacted by Section 120 of the Constitution.
Red light.
Yes, I think so. Well, Mr. Patterson, I think we've covered that ground. You've covered it, and we're very grateful to you for your submissions. Thank you very much.
I'm much obliged, Lord.
Thank you, Mr. Estefan.
Yes, thank you, my lord and my lady. Let me first of all deal with the issue of sovereignty. We've never questioned the sovereignty of any state. In fact, your lordships and my lady will see that we've never questioned the authority of the Legislative Council to make the laws in 1956. What we are saying is that with a sovereign parliament, not a sovereign state, with a sovereign parliament in the independent constitution, all that we were asking your lordships to do was to look at the existing law and to see whether it's inconsistent with the provisions, the lawmaking provisions of the Constitution, and if it is, to deal with it accordingly. We are saying void. This Section 2 to the second schedule says modifications. Secondly, Ibrahim dealt solely with the issue that the mere fact of independence had no effect on the existing laws. In St. Lucia, in direct contrast, the Constitution says what must be done with existing laws, unlike the case in Ceylon. But the most important point I wish to make in this reply, following along my learned friend's answer to one of your lordships about the codification of the 1952 Act. My lords, our case on the interpretation on Section 917A is that the law provides for it to be as far as practicable construed in accordance with English law and no longer to be construed in accordance with French law. That provision does not permit the importation of a law, especially a statute law, for the purposes of rendering redundant or even for rendering the common law ineffective in St. Lucia, but that's not the purpose of the reference to the Act. It's for the purposes of the construction of the provisions related concerning libel in.
Well, that's the second part, but Mr. Patterson relies on the first part of Article 917A.
Well, I don't see, my lord, how the two parts can be separated. They're not two separate provisions. They're one. And it says...
Well, one provision with two parts. And the first part says that the law of England shall extend to St. Lucia. And that is there regardless of whether he doesn't need to rely on the part about construing the articles. In fact, it doesn't refer to the particular articles that we're concerned with, so that second part isn't any relevance for our case.
Well, I respectfully disagree, my lord, because the Article 989 was incorporated in 1952 in whole.
Well, 989 was, but, well, we've been round this ground, but then there's a gap between 989 here and 991, and in that gap come all the provisions about defamation.
My lord, I'm only aware of the defamation provisions in Article 989.
Well, they're not in Article 989, they're in 989F onwards, which are different articles.
Yeah, but, well, my lord, we have interpreted, and this case has advanced, as all of the separate articles, as you call it, of section 989 are part of 989 referred to in section 917.
There was never any danger of those articles being construed in accordance with the law of Lower Canada or the Coutume de Paris, was there? Because they were fresh when this was passed in 1956.
Well, in the other provisions of the code were construed in accordance with French law, all of them. And in 1956, a decision was made by the Legislative Council to introduce the codification of the 1952 Act and to ensure moving forward it is to be interpreted in accordance with English law and no longer the French law. And the fact that that is there suggests to us, we respectfully submit, that there was no intention on the part of the Legislative Council to have provisions of the Act rendered redundant by each and every act of Parliament that the United Kingdom may make in relation to defamation. I think a holistic and contextual interpretation needs to be given to the word section 989. And to simplify it simply to 989 by itself, and leave the other sub-articles or the other articles exposed to being made redundant by the 2013 Act, we respectfully submit flies in the face of the intent of the Legislative Council, because they were all put in at the same time. And the final point I wanted to make, my lords and my lady, on the question of the comprehensive code that my lord, I think it's, I may be wrong. In the article of Sir Vincent Flossack at page 1745, he gives examples as to the exceptions from the Vagliano principle, that you may need to look at the previous law to see whether a term used in the code had a technical or a specific meaning, and that would not conflict with the application of the Vagliano principles or the fact that the code represented a comprehensive code, simply by seeking to find out what a specific word meant in the code. And that's what he says at page 1745, and I would ask your lordships and my lady to have a look at it. But unless there's anything else I can assist your lordships with, may I just get a quick instructions from my learned friends,
yes,
my lord?
Yes, please would you do that? There is one matter which I should have raised with Mr. Patterson, and perhaps I can deal with that while you're taking instructions. Mr. Patterson, I hope you can hear us. You mentioned that there were in the Civil Code 17 instances of the importation of English law. We'd be grateful if you could please submit a list on a single page, a list of which those provisions are.
I will do so, my lads, and I will also send the Canadian authority that I referred to earlier.
Thank you. Thank you very much.
My lads, while my learned friend is searching, the reference to the corpus of law appears at page 1298 of the electronic bundle. That's in the Iberleb decision. That's the one I was looking for earlier, the 1298.
Sorry, what is 1298?
The passage you were looking for.
The passage.
1298, that's the Iberleb decision where the court said independence as such did not, of course, alter the existing corpus of law itself.
Thank you.
Yes, my lord.
And Mr. Patterson, you're going to let us...
I'm sorry.
Forgive me, Mr. Patterson, you're going to let us have a copy of the Canadian Supreme Court decision as well.
I will send that today.
Thank you very much. Mr. Estefan, anything further?
Yes, I'm sorry to have interrupted you, my lord. I didn't realize you were still speaking. The final point we want to make, my lord, is to ask the court to look at the difference in language between Article 916 of paragraph 3 and 917A with respect to the second part of the, and indeed the first part and the second part of Article 917. And the difference in language, I think, is fairly clear. And my final point is, my lords, it would be, well, we rely on our earlier submission that Article 989 meant all of the articles in relation to 989 insofar as it concerns libel and slander. To take it and focus solely on 989 by itself would, I think, render almost meaningless the intent of Section 917A. These are our submissions, my lord. My lords and my lady, I'm sorry.
Thank you. Thank you very much. Well, Mr. Estefan, Mr. Patterson, we're very grateful to you for your submissions today. We're also grateful to your juniors and to those who are presumably in quite close proximity to you, perhaps just out of range of the cameras, those who've assisted in preparing the cases and the submissions for us today. We're very grateful to you all. The board will take time to consider the advice which it will in due course tender to His Majesty. Thank you all very much.
Thank you.